Hello friends, welcome to our channel Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation. In a significant development, a constitution bench of the Supreme Court on Monday declared that its 2014 judgment, which declared Section 6A of the Delhi Special Police Establishment Act 1946 as unconstitutional, will have retrospective effect. Stop. This means that Section 6A is held to not be in force right from the date of its insertion. Stop para. Section 6A of the DSPE Act required the Central Bureau of Investigation to obtain prior sanction from the central government to investigate corruption cases against an officer of the rank of Joint Secretary and above. Stop. This provision was struck down as unconstitutional by the Supreme Court in Subramaniam Swamy versus Union of India. Stop. The issue before the present Constitution bench, comprising justices regarding the retrospective effect of this ruling. Stop. Answering the reference, the court has now ruled that its earlier decision will have a retrospective operation. Stop para. Justice Nath, who early pronounced the judgment on behalf of the bench, stated the following conclusions. Stop. The struck down Section 6A of the Delhi Special Police Establishment Act was a part of the procedure only and did not constitute any new offence or sentence. Stop para. Article 20 within bracket 1 of the Constitution has no bearing or relevance in the context of the declaration of Section 6A as unconstitutional either to the validity or the invalidity of this provision. Stop. The declaration made by the Constitution Bench in 2014 as to the unconstitutionality of Section 6A of the DSPE Act will have a retrospective effect. Stop. This section is held to be not in force from the date of its insertion, that is 11/9/2003. Stop para. The court had reserved its judgment in November last year after hearing arguments over the pivotal issue, that is whether a 2014 judgment striking down section 6A within bracket 1 of the Delhi Police Special Establishment Act 1946, which mandated central government sanction for investigations involving certain government officials, would retrospectively apply to pending cases. Stop para. During last year's hearing, the contours of section 6A within bracket 1 of the Delhi Police Special Establishment Act 1946 were discussed at length, especially in the context of the protections safeguarded under Article 20 of the Indian Constitution. Stop. This clause bars the state from punishing an individual for an act that is not an offense at the time of its commission or imposing a greater punishment than what was provided in the law when the crime was committed. Stop. While Solicitor General of India argued that Article 20 did not apply to procedural provisions, citing a previous Supreme Court ruling, senior advocate contended that Section 6A should offer immunity not just from conviction but also from investigation, and that such procedural safeguards formed a part of Article 20 within bracket 1. Stop. Apart from this, additional Solicitor General S.V. Raju appeared for the Central Bureau of Investigation and touched on the potential consequences of holding that Section 6A would have a prospective and not retrospective application. Stop para. Under consideration by the Supreme Court Constitution Bench was the question of whether a person could be deprived of any immunity conferred statutorily by retrospective operation of a judgment striking down the immunity granting provision. Stop. This issue was referred to the five judge bench in March 2016 by a division bench of the court. Stop para. This case stemmed from an arrest made under the Delhi Police Special Establishment Act 1946 without prior sanction, prompting a legal challenge on grounds of violation of Section 6A, which mandated the Central Bureau of Investigation to take prior sanction of the government before investigating an officer of the rank of Joint Secretary and above in corruption cases. Stop. The Delhi High Court ruled that since the Central Bureau of Investigation had initiated the investigation before the arrest, the exception contained in subsection within bracket 2 of section 6A for support arrests would not apply. Stop. Accordingly, the High Court directed the agency to seek central government approval for re-investigation. Stop. This decision was challenged by the CBI in the Supreme Court in 2007, but in Subramaniam Swamy within bracket 2014 stop. However, the application of this ruling to pending cases remained unclear, which is why the issue was referred to a constitution bench in the current case. Stop. The five judge bench reserved its verdict in November 2022 after hearing the oral arguments. Stop.